To reiterate Gelo's points already, we've had a very ambitious time schedule throughout the conference, but this is by far our most ambitious session. We have 5 speakers and 30 minutes. The idea, however, is to really keep it short and sweet, to give you some key pointers, key messages, potentially key points of controversy that have come from the different sessions, also to enable you to get a bit of a flavor of potentially those sessions that you weren't able to attend because we had a parallel working time structure. We will not have time for Q&A in this session, but let me use this opportunity to instead remind you that we very much see this conference as well as the notes as a collaborative exercise, as a process of dialogue. So please do stay in touch with us, the organizers, via email or otherwise to share your thoughts. We have 5 distinguished members of the Odysseus Academic Network with us who have kindly agreed to take on the tasks of the short messages. I'll introduce them one by one as they present their respective sessions, and I kindly remind them again of the crucial issue of staying within 5 minutes. First up is Daniel Thum, professor at the University of Constance, who will be reporting on the financial framework session and the agency session. Please.
Indeed, thanks. These 2 themes were absent from the debates in Tampere 20 years ago, and that may have been a wise limitation. At the time, as Prime Minister Lipponen reminded us in his keynote speech, he said, if we had discussed finances, we would never have concluded the Tampere European Council. Today, the situation is, of course, different. We all know that decisions on the multi-annual financial framework are forthcoming, and it looks as if Justice and Home Affairs will be one of the big winners and will receive more funds. At the same time, the panel reminded us that we should remain realistic. The overall amount of the EU budget will remain at a bit more than 1% of GDP. Thus, the Justice and Home Affairs slice will necessarily also remain limited, and this entails that the member states will retain the brunt of the responsibility to finance migration policies. EU money can support the member states, but it cannot undo their residual responsibility. Moreover, the Commission representatives told us that it can be attractive to throw more money at Justice and Home Affairs to distract from the absence of legislative reform. In other words, money alone cannot fix the deficits of the asylum system in particular. We also need legislative reform. Regarding the structure of the budget, there was widespread agreement that more money should be given to Justice and Home Affairs, and there should be more flexibility in the allocation of funds. Other aspects are more controversial. A prime example is conditionality, which links the funds to the rule of law, and the rapporteur, Professor Goldner-Lang, argued that such provisions on conditionality will only work in practice and sustainably if they are politically accepted by the member states concerned. She also reminded us that the internal allocation of funds reflects controversial policy choices, while the external budget on development and the neighborhood is quite massive. Internal funds for human rights compliant asylum procedures and reception conditions are limited. In another keynote earlier today, former Commissioner Vitorino told us why the topic of the second session, that is agencies, is so essential. He said one of the lessons learned since Tampere is that legislation alone is not enough. It has to be implemented on the ground. And this brings us to the agencies, which are the best instrument we have to close the implementation gap through European action. And this implementation gap, we all know, it's epitomized by the deplorable state of the Greek asylum system. The dynamism of EASO and Frontex, which we discussed, is, of course, one of the most fascinating developments in EU law. And the Frontex representative told us that at this very moment, they seek to hire 750 new staff. That's, I think, a telling example and quite impressive. At the same time, the dynamism of the agencies raises formidable practical and legal challenges, and these challenges include the tension between the operational and the supervisory function of the agencies, which have to control a system they help sustain at the same time. Also, there are internal governance issues if the agencies are torn in a tension between independence and accountability, and our rapporteur, Lilian Zurdi, made some practical suggestions how to improve the situation. And while the Frontex regulation has been reinforced repeatedly, EASO reform is awaiting adoption, and as a result, EASO is currently working on de facto tasks which legally are at the margins, if not beyond, of its mandate. Finally, the composite nature of both agencies, which combine national components with EU actions, this composite nature raises complex challenges of legal control by courts or by other institutions. We discussed corresponding solutions, and for anyone who wants to learn more, I highly commend two excellent reports by our rapporteurs, which both managed to present a highly technical and complex development field of EU law in an understandable manner. Many thanks.
Thank you very much, and thank you for keeping the time. Next up is Professor Jens Vested Hansen from the Aarhus University. He'll be talking about the panel sessions on migration and development and the partnership framework. Please.
Thank you very much. And I would like to begin where Daniel ended by saying that we had two excellent reports or background notes as a starting point for the discussion. And I think the discussion showed the narrow connection between the topics and the analysis of the two background notes. The first one was on migration and development, and here it was a main point of the background note as well as the discussion actually, that Tampere has been implemented or understood in a way that has often put main focus on root causes, which reflects a flawed and oversimplified perception of the phenomenon of migration and a similarly simplified or distorted approach to migration management. As regards development issues, this has resulted in defining an aim that is preventing migration, and the means have often been to set up conditionalities of development aid, which, as the background note points out, often results in diverting development assistance from non-sending states, among which many are among the poorest. So it is in one way distorting the whole purpose of development aid as such. When it comes to the global approach and partnership framework, one of the main points of the paper and also of the presentation yesterday was the tendency to confuse border controls and migration management, which in turn also leads to the conflation of the two policy areas and the practical measures taken in these regards. This in turn results in the increasing tendency, which is known for all of you, of course, towards extraterritorial migration controls being carried out, which often raises challenges to human rights, not to say outright violation issues. And also, according to thorough statistical analysis of the background note, actually could seem to be out of proportion to the true nature of the problem of irregular migration. Across the two sessions, we had some common observations and some common concerns. One was the overall tendencies to this distorted approach to migration policy, which presupposes or assumes that migration is a problem that has to be stopped, but as one of the panelists yesterday pointed out, it is rather to be seen as a phenomenon to be managed. And there were various constructive proposals for alternative approaches, such as a more proactive or creative kind of measures towards attempts of circular migration, emphasizing the impact of remittances as an investment source, and thirdly also to work more on the interconnection between skilled labor recruitment and educational programs. The second common observation was about the impacts of these third country partnerships on international relations, the very idea of setting up conditionalities in the context of international development assistance can be seen as irreconcilable with the idea of partnerships in the true meaning of the term. Next, the lack of respect for, or rather, the extraterritorial migration controls which are being imposed on neighboring states, not least in Northern Africa, will often be resulting in a kind of disrespect for emerging regional or sub-regional free movement regimes in Africa. And that altogether also means that the various measures or mechanisms employed in these third country partnerships will often be of a kind of extra legal nature, which in principle and sometimes also in practice can be seen as challenging the principles of the rule of law, as we have seen, for instance, with the EU-Turkey arrangements. Two final meta-observations. One is that it was pointed out that there is at sometimes dilemmatic relationship between research and policy making. And we had some interesting comments on that in one of the panels yesterday, where it was pointed out that as long as we realize that we have different roles and should be working independently, then there may be actually, as I think this event has shown, good preconditions also for having a mutually beneficial relationship between the two fields of activity. The second observation was that it was pointed out that there is a need to widen research perspectives. Not least as lawyers, we tend to be very Eurocentric, obviously. I'm among the sinners here. But it was pointed out that there is a need not only for independent research and more research, more independent research, but also for research which is sort of widening the perspectives towards migration narratives and issues beyond Europe. So that was one of the sort of reflections which I think we also ought to share here. So finally, I don't think we can conclude any need to revise or amend Tampere, but there could be lots of reasons to reconsider the ways in which the relevant points in the Tampere conclusions are being implemented and transformed into actual policies. Thank you.
Thank you very much. We now move to Jean-Yves Carlier, professor at the Université Catholique de Louvain, who will be talking about the legal migration session and the integration and value session. Please.
Yes, this workshop was about fair treatment of third country nationals. And the first session was devoted to legal migration. The background report was written by Professor Kees Groenendijk, Emeritus Professor of the Radboud Universiteit Nijmegen in the Netherlands. The second session was devoted to integration and values, with a common background report from Professor Ilke Adam, Vrije Universiteit Brussels in Belgium, and Professor Daniel Tim. I have not to introduce him again. I must say that the most important contribution to this workshop is, in my view, the content of these background reports, which I will not summarize. You have to read them. Let me share 3 points with you, starting with the second session. The discussion was quite controversial on the notion of integration and the word integration itself. Should we talk about integration, disintegration, inclusion, exclusion, insertion, etc.? There was some consensus that beyond the word, what is important is what do we need? And the majority answer was the capacity to participate equally to the society. And this is a process that must be done as a joint process, a two-way process, like it was said in the background report, with civil society, local authorities, religious communities to build bridges. To support this, the Commission could propose a new comprehensive plan of equality, which is broader than integration. It will therefore be more about action than legislation. This leads me to the second point and the first session. The most important discussion on legal migration was probably this question: do we need new legislation? Do we need recast secondary law? Some consider that the situation is no longer the same than 20 years ago. Others, such as the author of the background report, consider that we could focus on better application of existing law. I share this view. But as a way of action, it was also said that the Commission could develop pilot projects with serious evaluation and assessment, for instance, for self-employed migrants, and here maybe with legal sources or for routes of legal migration. And my third point is a personal remark. Several participants mentioned the importance of keeping the spirit of Tampere, even if Tampere was 20 years ago. They are right. And this spirit should bring us back to the first workshop and the need of a global approach and the question of the role of EU and that EU could play in the evolution of the global compact, which was not mentioned at all in the discussion of our workshop. Why this issue of legal migration and integration are on the agenda of the global compact for safe, orderly and regular migration. In the same spirit, more than 65 years ago, in 1952, one of the founder fathers of Europe, namely Jean Monnet, in one of his speech in Washington, said, and I quote, "6 European countries have not committed themselves to the great undertaking of breaking down the barriers that divide them, to raise higher barriers between them and the outside world." I leave you with this.
Thank you very much. We move over. We'll have a chance to thank all of our excellent rapporteurs at the end. We move to Professor Rebecca Stern, who is joining us from the University of Uppsala, and she'll be speaking about the SEA sessions and the Dublin and Solidarity sessions. Please.
Thank you. This is sort of a challenge since the second session ended about, an hour ago, and I was working through the coffee break with this, so it might not be as structured as the previous presentations. But I wanted to share with you some of what I found was some of the key messages in these two extremely rich sessions with two extremely rich papers that I encourage you to read if you have not done so already. I will treat the sessions together since they very much talked about the same things, but from perhaps different aspects. From different perspectives. I'd say that the first of the key messages I would like to share with you is the emphasis that was put on the value of fundamental values and principles, including the rule of law. That we need to identify which are the fundamental values on which the system is based and should be based. And it was pointed out in the first session that the lack of compliance with fundamental values is a main reason to why the system is in a gridlock. We need to go back to basics in a way. Solidarity is, of course, a key concept, or perhaps the key concept. You could perhaps even summarize the discussion in the two sessions with one word, and it would be solidarity. However, what solidarity means can be discussed, and this was also one of the main themes throughout these two sessions. Is it symbolic? Is it substantive? With what and with whom should one show solidarity? And we are not in agreement, I think, on this point. Allocation of responsibility was also a key theme, which ties in with solidarity. It was pointed out, in particular in the second session on the Dublin system, that allocation of responsibility does not only has to mean a sharing of people, which we all agree upon is difficult. It can also be other things, such as, for example, financial sharing of responsibilities. The second key message I would like to share with you is that implementation in practice of existing law is a key issue. Differences in interpretation of key concepts must be harmonized, protection gaps must be addressed and closed. And mere changes of legislative documents won't lead us anywhere. A bad reform, it was stated, is worse than no reform. I certainly agree with that point. And this was true both in relation to the common European asylum system and to the Dublin system in particular. So just making something new might not lead us to somewhere good. Third key message is that trust in the system, both the SEAS and Dublin particularly, must be re-established, both within states so that they actually apply the rules that are in place, and with asylum seekers, so that they might not like the system we have, but at least accept the way it is implemented and works for them. And on that note, it was stressed in the sessions, both sessions, that we need to work with those seeking protection, with the individuals seeking asylum, not only punishing them for not following our rules. So perhaps we need to look for a more inclusive system, a system that is not only top-down, but also looks upon those who are the subject of the system. Talking about individuals, that leads us into the issues of controversy that were discussed during these two sessions. One major issue of controversy was the issue of secondary movement. How should this be handled? Root causes to secondary movement must be addressed, and if we want to counteract secondary movements, should this be used by using sticks, as is the case today, or should we try more to use carrots? Looking into what could be legitimate reasons for secondary movement, what would be the incentives for asylum seekers not to move from one country to another. A key element of this discussion on secondary movement is the issue of free choice. We could talk about that all day. It's an extremely controversial concept and difficult in many ways. You could perhaps summarize that the point of view of member states is that free choice is good in theory, but it needs to be balanced with some kind of foreseeability and control on the part of the member states. In another perspective, increasing the element of free choice might lead to that a lot of unnecessary transfers are avoided and a lot of human suffering is also avoided. It should also be kept in mind, and this was pointed out, that secondary movement or free choice needs not to be a question of one or the other. There is a middle ground to be found between the position of state parties and individuals, as was pointed out by Francesco in his final remarks. Perhaps, I know that I have no time left, but perhaps this discussion in these two very rich panels could be boiled down even further than these points that I've just mentioned. And perhaps one could say that it's about that we need to start with the principles and fundamental values. We need to agree on which these are and what they mean. And we need to take solidarity seriously. And in doing so, we need to strive for robust solidarity and to strive for an understanding of what this could mean that is at least acceptable for all those who are actors in this game. Thank you.
Thank you very much. Over to Dr. Madalina Moraro, who is joining us from Masaryk University and who will be speaking about the Schengen sessions and the return and readmission session. Please.
Thank you, Marie, for the introduction. I have to start first by apologizing because I realize I'm the last speaker, so I'll have to be extremely brief and I'll not make justice to all the discussions in the two panels that I assisted. We actually had a very rich debate, and if I had to choose two buzzwords for the discussion we had, these would be emotional and mutual understanding. And we had four controversial topics. First was the Schengen Border Code, The second was Schengen membership. Third, the recast of the Return Directive. And last, return admissions. So what I would like to do is basically highlight the common issues that have come up through both of the sessions. And the first one would be necessity of legislative reform. So whether given the challenges on the ground, the best way forward would be legislative amendment, or maybe perhaps that has been already emphasized in previous session and also yesterday, whether the way forward should be actually enhancing effective domestic implementation. A second issue that was raised was the idea of conditionality between the two main immigration instruments, that is, Schengen and the Return Directive, on good performance in the common European asylum system. This was very controversial, and this is where the emotional came up in the panel, particularly the first panel on the Schengen. And the main idea that came out from the debate was that such a conditionality would be harmful, and especially harmful for solidarity and trust. And maybe what should we concentrate for the future is on membership that is based on the proper implementation of the Schengen acquis. A third issue that was common, I think, for both sessions was the idea of how we measure effectiveness. And that is effectiveness for border controls, and secondly, effectiveness of returns. The idea was put forward that actually in terms of returns, effectiveness should not concentrate only on the number of returns, but that we should look forward also for sustainability and also for human dignity, which are key and important aspects to have in mind. And also in terms of effectiveness for Schengen, it was the main idea, and I think there was a common agreement that we lack data and that there should be more research invested on actually measuring effectiveness on border controls. And one another topic that I think was very important is the pending recast of the Return Directive. I have to apologize because probably I will concentrate and I speak more on the return, because this has been the bread and butter for my research for the last 5 years. And I had the privilege of actually being involved in a European project that has looked and compared the judicial implementation of the Return Directive in all 28 member states. So I can actually feed a bit more into the debate that was carried out in the panel on the return. And one idea was how do we actually look at the Return Directive, and how do we deal with legislative reform in this field? And the key word and the key idea to take home is that perhaps we should also go back in time and think at the moment of the adoption of the Return Directive. Initially, when it was adopted, it was called the Shameful Directive, as we all know. But with the help of courts, it has actually proved to be a normative example also for the Council of Europe and other states. So this actually leads me to the last point that I want to make with the importance and the vital role of courts in upholding constitutional values, but also important principles in return and readmission, and that is voluntarism, proportionality, and most importantly, the respect of the rule of law. So with this, I would like to end my summary, and again apologize if I didn't make justice to all the insightful comments and presentation, but I would encourage you to actually have a look at the background notes. One of them was written by Marie de Sommer and the other by Thomas Molnar. They're wonderful papers that should be disseminated as much as possible. Thank you.
Please, no need to apologize. I think we can all appreciate the very difficult task we have given to you. Thank you to all 5 of you for having managed to give such rich contributions in the very limited amount of time. I think we've all benefited. And with that, please thank our kind rapporteurs one more time, and I hand over to my colleagues.